Welcome to you, Counsel. In today's lecture, I will explain the basic principles of evidence that will help you in identifying the appropriate evidence that you would need for your case in a civil court in Ontario. Please note that this lecture is not legal advice, so if you have any specific questions regarding your issues, you should contact a lawyer or a paralegal or the Law Society of Ontario for a referral. In today's lecture, I will explain what are the sources of evidence law that the judges and the courts consider in making decisions about evidentiary matters. I will explain to you the basic principles of the evidence law that is applied by judges. I'll try to explain this further by way of an example. And then finally, I'll talk about the discretionary powers of a court or a judge with respect to the evidentiary matters. There are two sources of law with respect to evidence. Number one is statutes, and number two is common law, which are the decisions of judges with respect to evidentiary matters, and it contains many principles of evidence. When judges are deciding on evidentiary issues, they make those decisions on the basis of a combination of common law principles and statutes. Regarding statutes, we have the federal statute, which is Canada Evidence Act, which deals with all matters that are in the federal jurisdiction. With respect to provinces, each province has its own provincial legislation regarding evidence, and in Ontario it is Evidence Act, and other provinces will have and territories will have similar legislation. And the third item with respect to legislation are the rules of civil procedure. They also contain various rules with respect to how different pieces of evidence are entertained by judges in courts. Let's go to basic principles. There are three basic principles with respect to evidence, and the courts will consider those principles in deciding whether the evidence is relevant and need to be included in that court action or in that legal process. First principle is relevancy. The evidence needs to be relevant. What does that mean? The specific piece of evidence that you're presenting, it should increase or decrease the probability of the truth of a fact. So the evidence is whatever you have stated, whatever facts you have alleged in your pleadings, that specific evidence that you are providing, that you're submitting, should increase or decrease the probability that that fact is in fact true, right? So the key thing you want to remember about relevance is that the threshold for a piece of evidence to be relevant is very low. As long as that particular piece of evidence can somehow add value with respect to the truth of that fact, either it is true or untrue, then that piece of evidence would be considered relevant. And I will explain this by way of an example, so hopefully it will be more clear. The second principle is called materiality. Materiality is a piece of evidence that when you are trying to prove a specific fact, then that specific piece of evidence must have any legal significance. So in this situation, there is a specific legal test that is connected to that piece of evidence, or evidence is connected to that specific legal test, which is why that particular piece of evidence becomes material. So broadly speaking, you will have a lot of pieces of evidence that will be relevant, and from those relevant pieces, there will be pieces of evidence that will be material because they are corresponding to a specific legal issue that you have raised or you are defending, and that's what makes those pieces of evidence material. And finally, the evidence that you're submitting ought to be admissible, and what this means is that there are no exclusionary rules that apply. By virtue of the application of those rules, those pieces of evidence are not admissible. So in some cases, evidence that you have presented may be relevant and material, but because of the application of exclusionary rules, and there are many exclusionary rules, today we're not discussing that, but in another lecture we'll talk about it, but because of the application of exclusionary rules, relevant and material evidence is not admissible in that proceeding. Examples of evidence that could be excluded is hearsay, right? So in hearsay, evidence could be relevant and material, quite relevant, quite material, but because the evidence is hearsay, it ought to be excluded. So the judge will exclude that. And then there are exclusions to hearsay evidence, further exclusions, which will allow hearsay evidence to be admitted. But we're not discussing that today. Character evidence is another example where character evidence may not be admitted. Similarly, there may be circumstances where opinion evidence is not admitted. So there are a number of categories of exclusionary rules that may apply. But what you want to remember is that for a judge to accept any piece of evidence, it has to be relevant and material and has to be admissible. Let's go to an example and see if we can explain the concept of relevance and materiality a bit better. I take an example of a case where you had retained a contractor to renovate your kitchen. And in that process, the contractor did not do the job properly and you incurred damages as a result of inferior work or the contractor's work that was not performed in accordance with your agreement or instructions, and you have incurred damages and you have sued the contractor in court for your damages. Within that context, I am giving an example of one specific issue, which was with respect to the countertops in the kitchen. You claim in your statement of claim that you had an agreement with the contractor that he will install granite countertops, but the countertops that he has installed are actually quartz, and which was not something that you had agreed upon, and you had to have the quartz countertops removed and then granite reinstalled, and because of that you have incurred damages for which you are claiming damages before the court. Now, normally, if you have one contract, one piece of document that specifies what is the agreement, what is the scope of work, what is the cost, what material will be used, then that piece of evidence will be relevant and material, and you will produce that in order to show what was agreed upon and so what was the nature of the contract. But let's assume in this case that there was no written contract, one piece of document. The way you had agreed to all of the terms with your contractor was by emails and text messages, which is not unusual. So all of the evidence that you are going to present with respect to proving your case is going to be from the emails and text messages that you corresponded with your contractor. Now, in those emails, let's assume that you had emails that were discussing countertops, right? And so these are, imagine a bunch of emails where you said, my budget is $5,000 for countertops. I would like to have granite countertops. The contractor, for example, says, well, $5,000 is a low budget. I think you should consider some other material, maybe quartz. So all of these emails will be relevant and material. Whereas if there are other emails that are discussing kitchen cabinets, that may be relevant, may not be relevant, depending upon the circumstances of your case, but they're not material. So what does this mean? Why are these ones material and these ones are not material to this particular case? So as I said, for materiality, you need to understand what is the legal significance of that specific piece of evidence that you are providing. In this case, because it is a breach of contract case, so there are sort of I would say there are three basic things that you need to legally prove to the court, right? Number one, that there was an agreement, there was a contract which specified that the material for the countertops will be granite, right? So there's a contractual agreement for the installation of granite countertops. That's the item number one. Second item that you'll have to prove to the court is that the contractor breached that agreement, right? So you will provide pieces of evidence proving to the court that what was installed was not granite, was quartz. And the third thing that you will have to prove to the court is that because of that breach, you incurred damages. So in this case, you will be able to show, for example, invoices for removal of cords and for the reinstallation or purchase of granite countertops and installation of that, right? So there are three categories, three things that you have to prove in order for you legally to get your damages that you're claiming. So the first item is that you have to prove that there was indeed a contractual agreement between you and the contractor for the installation of granite countertops. Now, the emails that are talking about countertops are relevant and therefore material. But the kitchen cabinets emails are not material because they are not going to prove the agreement of granite countertops. Now, if you have issues about kitchen cabinet as well with the contractor, then of course these emails will may be relevant and material, but depending upon what kind of issues you have. So the point that you want to carry from this discussion, from this example, is that one of the important things that you have to do in selecting evidence is to understand what is the legal test that you have to meet, either to prove your case or to defend your case, and then what are the pieces of evidence that correspond with that legal test, and therefore those pieces of evidence will become material. Let's go to our discussion about the discretionary power of the court. What you want to remember from this discussion is that the courts have this broad discretionary power with respect to evidence. So in certain circumstances where the evidence may be relevant, may be material, and may be admissible, there are no exclusionary rules that may apply. And even then, the judge may decide that that particular piece of evidence ought not to be admitted with respect to this particular trial that you're dealing with. How do judges decide that? They apply this test where they assess the probative value of the piece of evidence that you have provided versus the prejudicial effect of that evidence. Let's do this by way of an example. The example I've chosen is a bit extreme, but it illustrates the point probably a bit better. Let's take an example of a murder case where the question is that does the Crown need to provide the photos of the deceased or the person who is murdered as evidence to show that the person has indeed died? The court will consider the probative value of those pieces of photos to confirm the death of that person. And there may be other ways to show that the person has died. There could be a death certificate. And so in that situation, the court will consider what is the benefit of having the deceased person's photos as part of evidence to prove that the person has died. And on the other hand, the prejudicial effect may be that seeing the photos of the dead person may have some sort of psychological impact on the minds of the jury, and that may have an impact on how that trial is decided, or the process of trial is taken by the jury. So in that case, the court may decide that there isn't much probative value from those photos to be included as evidence, even though they are admissible. A death certificate from a hospital or a doctor is sufficient, and so the court may say we're not going to admit the photos. But for example, if the issue is that those photos are being presented to prove the method of killing of that person, then the probative value may be much higher and the prejudicial effect may be much lower. So in that case, the court may allow the admissibility of those pieces of evidence. So in all of this, what you want to understand, the two things you want to carry is you want to make sure that your evidence is material and is not otherwise inadmissible, and which means that you need to understand the legal significance of the evidence that you're using. And generally speaking, what you want to remember from all of this is that judges generally like to have all of the evidence admitted as much as possible, right? So if it's a clearly hearsay evidence or there's a prejudice to the other side, then of course the judges will not allow that evidence. But otherwise, judges will like to have all pieces of evidence, because then the judges can assign different weight to different piece of evidence. If they believe that a particular piece of evidence seems to be weak, they may assign a lesser value to that piece of evidence, may rely less on that, and there may be other evidence. So they like to have that option so that within the context of the entire case, they can figure out which pieces of evidence are more appropriate for them to make their decision on. So hopefully this lecture gives you a broader understanding of the fundamentals of evidence law. As I indicated earlier, evidence law is quite complicated, it's intricate, but if you have this basic understanding, at least you will be able to figure out what kind of evidence is relevant and material to your case, and you will be able to make that selection better. Thank you for watching.